Have you ever wondered what will happen to your assets after you pass away? Your estate plan is your chance to make sure your wishes are honored. But did you know that sometimes people can challenge your last will and testament? In today's video, we'll show you how to prevent disputes and protect your estate. When disputes arise during the probate process, it can increase costs and prolong the time it takes to settle your estate. This means less for your loved ones and a longer wait before they receive what you've left for them. To avoid these unwanted outcomes, here are some simple tips to reduce the likelihood of a dispute. Tip 1. Work with an experienced estate planning attorney. While online forms may seem convenient, they can increase the chances of legal battles later on. By working with an experienced estate planning attorney, you can ensure that everything is done correctly and have the best defense against disputes. Tip 2. Choose the right executor. Take the time to consider who will be responsible for executing your will. It's important to choose someone who can handle the job while dealing with their own grief. If possible, select someone with legal experience, as the right executor can discourage challenges. Tip 3. Help your executor prove your testamentary capacity. To challenge a will, someone must claim that it's legally invalid. To prevent such claims, you can have a mental examination conducted by a qualified medical professional shortly before or after creating your will. It's also essential to meet with your estate planning lawyer alone to discuss your wishes and execute your will in their presence and with witnesses. Tip 4. Consider including a no-contest clause in your will. A no-contest clause can discourage beneficiaries from challenging your will. This clause penalizes anyone who contests it by potentially losing what they would have received. Including this clause can act as a deterrent against disputes. Tip 5. Use a letter of instruction to explain controversial decisions. You have the right to distribute your estate as you see fit, even if it's not popular with your loved ones. If you anticipate disagreements or questions about your choices, consider explaining them in a letter of instruction. This letter can be shared with your family before your passing or used as evidence in case of litigation. By following these steps, you can minimize the likelihood of disputes and ensure that your estate plan is carried out according to your wishes. Talk to an estate planning attorney today to protect your legacy and provide for your loved ones.